I wish to welcome everybody. Thank you all for joining. We really appreciate your time and effort that you've made to join us. What we will cover today is, as our says on our screen, is the key challenges in data privacy implementation and how data privacy manager helps organizations overcome them and ensure POPIA compliance. Our agenda that we'll cover today is as it's set out there. So I'll do an introduction to the speakers. I'll give you a brief overview of Nvious solutions and DPM. Next up will be POPIA compliance, which will be covered by, as I said, I'll take you through the speakers, and then next subject matter will be the most important part of it, as the navigating the challenges, and then we'll have a Q&A. You're welcome to put your Q&As in the chat, and after we've finished, we will also take all questions and answer them accordingly. Thank you very much. So our speakers today, we're joined by Anrich Stryp, who's an admitted attorney of the High Court and also an associate and trademark and copyright practitioner at Bračić Law Incorporated. Anrich has qualified, he's got a BA in LLB, the University of Pretoria, also a postgraduate in international contract law from Harvard University. We have on us Marijan. Marijan is the CEO of Data Privacy Manager and also the product owner. And as you can see, he comes with a wealth of experience. He's a data protection expert and has extensive experience in analytics and data management. He's deeply committed to helping businesses navigate and comply with data protection regulations and laws globally, ensuring that they meet the highest standards of privacy and security. Myself, Eugene, I'm the founder and CEO of Nvious Solutions. We're based in South Africa. I've been in the industry for more than probably closer to 35 years. And during this period, I've held various positions from systems engineer when I started out, pre-sales, CAM, account director, GM. And yeah, I've held these in both blue chip international companies and obviously in local entities as well. So those are the three of us. The Nvious Solutions is a majority Black female-owned level 1 triple BE company. We bring the best of breed technology to the South African corporate market. Our key focus areas is on data privacy, discovery, classification, protection. And then we also do what is called a managed security service provider. There we are powered by Security HQ, which is one of the top MSSPs globally, rated in the top 4, top 5. We believe with our technical expertise combined with our operational proficiency, will allow us to design and implement secure solutions to protect our clients against the ever-increasing cybersecurity threats. And we believe in our solutions are secure by design. So whatever when we design a solution, it's from the outset that we incorporate our security into those solutions. We maintain a constant focus on improving our service quality, increasing user satisfaction, and delivering increased business value. DPM, obviously one of our key solutions that we take to market. DPM is a cloud-based software platform for privacy management and automation. I'm not going to go into detail about the slides. What I can tell you about DPM, we've gone on an extensive search for a data privacy solution. And the one that we came up with, we've gone through quite a few of them. And DPM by far sets the standard for it globally. We've signed up as a partner for DPM with the exclusive partner for the SADC region, South African SADC. So DPM is a modular-based solution, as you could see. So they do the state of privacy assessment, your data mapping, privacy program management, content mastering, and data removal. And all of those has got sections, subsections underneath them. So we don't do box drop and that you have to take it from end to end. It's a modular system and you can buy it accordingly. Most important is obviously that we believe, and we with our clients, is that you should do a state of privacy assessment if you don't know where you're at within your privacy frame, and then we will take it from there onwards and advise you accordingly. What we also do is we focus on data-centric security. On this, we believe very much, or our solution set is not encryption, but rather tokenization. And the benefits from that is as I believe, it's so much better than encryption, in that you cannot decrypt it. It's absolutely secure. The solutions has been successfully sold, as you can see, into global companies, and including the likes of our local banks, and some of the 3 of the 15 largest retailers globally, and 2 of the largest credit card processors. On the MSSP, we've partnered with Security HQ, which has been around for approximately 25 years. Security HQ, globally rated MSSP, they have in excess of 500 analysts alone by themselves. They got SOCs across the world, so it's a follow the sun effectively, so 6 to 8 SOCs globally. And as you can see, they split up into various, your detect and response, your managed security, and cyber risk management. And as you can see, under each one of those, there's the various ones that you can choose from. But once again, we'll come in, we'll do an assessment, we'll sit down with our clients, consult with them, bring in our experts, cybersecurity experts, and we'll take the clients through it. Locally, we've done quite a few fantastic solutions for clients on that, I believe. And these are our key partners that we have, our strategic partners, which, as I've mentioned, is obviously Data Privacy Manager, Comfort, and then Security HQ. And with all of these, as you can see, the partner status, we're accredited with Security HQ, we're a certified partner in Comfort, and an exclusive partner to the Data Privacy Manager. That's it from my side. I'll now stop sharing, and it will be over to Anrich to continue on the POPIA compliance. Thank you.
Thank you very much, Eugene. Good day, everyone. It's my privilege to talk about the POPIA compliance. I know we've been living with the legislation for a few years now, but I'd just like to give you a little brief overview of the conditions that's proposed by the POPIA Act, and how it links with Nvious and how they can assist you with protecting your information and your privacy in your organizations. So let's start from the beginning. In 2013, the Protection of Information Act, that's POPI, it was signed into law. It was only a few portions that was signed into law. I'm fairly sure not a lot of people were aware of this, as we only got aware of it in 2020 when it was actually enforced, and was fully enforced from the 1st of July 2022. In 2016, the information regulator was already established, and in 2018, the POPI regulations were published. So what's the purpose of POPI? Like, why do we have it in existence in South Africa? Why is it relevant, and why is it important? So the purpose of POPI essentially is to govern and to set the limitations and the rights of a data subject in line with our constitution. So in the constitution, if we look at the Bill of Rights, we have the right to privacy, and POPI essentially takes your right to privacy, puts it into a formulation, setting out the limitations of how information may be accessed and how it may be governed and enforced in our law. So POPI essentially sets out 8 conditions in terms of our law. That would be accountability, processing limitations, purpose specifications. Then there's further processing limitations that's imposed. The Act also looks at information quality, openness, security safeguards, and that's where Nvious comes in, and data subject participation. So if we look at the first condition, that's referring to accountability. So the Act is very, very specific. If one has to take into account who is accountable, we would say everyone is accountable. So if you're an employer or an employee, everyone is accountable. So essentially in your organization, you have to ensure that the right structures are in place to make sure that your employees follow your lines, follow your internal processes to make sure that there's no data breach or no data leakages within your organization. The Act is quite strict when it comes to sanctions. There's provision made for fines and for imprisonment if you do not comply with certain of the provisions within the POPI Act. Fines can go up to 10 million rand or 10 years imprisonment if that's if it's found that you are guilty of a data breach due to your negligence. The person whose data you process can also institute a further damages claim And that can be in the form of compensation for a loss as a result of your negligent data breach or any reputational damages, because we don't want our personal information to be out in the public domain now, do we? The second condition POPI imposes is our process limitations. So the POPI Act essentially introduced the concept of minimality. So that directs that personal information can only be processed for a specific purpose and if it's relevant. So once your organization obtains information, you have to pause and ask the question, what's the purpose for why I'm keeping this information and why it's relevant to my specific instruction or specific to my organization. POPIA also sets out that prior consent is required, and now this is a legal requirement. The data subject can also, of course, withdraw his consent at any time. So therefore, as an organization, make sure you have consent. The POPIA Act provisions expressly, and it states that any voluntary, specific, and informed expression of will in terms of which permission is given for the processing of specific information. That's what POPIA sets out as consent. So you have to have information that's being processed for a specific reason and for a specific purpose. Therefore, it's encouraged that personal information should only be obtained directly from a data subject or from public records. So if you have access to a public domain, those informations can be used freely. If it's not available publicly, then you have to approach the data subject directly to obtain their consent. And as I said, step back, ask yourself the question, what's the information I'm requiring from the data subject and why is it relevant? And why am I obtaining these information? I would also say that there's a third requirement outside of the scope and purpose, and that pertains to reasoning. So that's very much in line with the purpose of why you have this information. So if the data regulator is at your doorstep and he asks access and reasons to why you have certain information in your possession, remember the onus always rests on you as the data processor to prove that the information you have in your possession was in line with the original purpose. So then we also look back, is there consent? Is there purpose? Yes. So a few examples I always say to companies is if you obtain information from clients, what's the specific purpose? And most of the answers we always get to say that it's in line with either marketing they send out, so newsletters, etc. Or if it's for a legit purpose within the company, for example, invoicing, then that will be in line with a purpose in terms of our POPIA Act. So like I said, the third requirement is a purpose specification. So we have to be specific and there has to be a lawful purpose when you collect personal information. So the data subject, and in most of your cases, this will be your clients, must be made aware of the purpose, and the personal information must only be retained for as long as the purpose required. So if you're in the trades industry and you only provide a service to a specific purpose and you obtain information from your clients, and let's say it pertains to invoicing, just know once you are done delivering the service and you've invoiced the client with the information, that is your timeline for when that information may be retained. You can't contact the client or the data subject afterwards with further newsletters or anything. It's not in line with your purpose, and therefore it's not in compliance with our POPIA Act. So therefore, I always say delete that number when the data subject doesn't want to hear from you anymore. So they will re-engage you when they want to have their services. So respect that privacy. The further condition POPIA sets out is another processing limit. So it essentially says once the personal information is collected, further processing must be in accordance or compatible with the original purpose of collection. So once again, we will go back to step 2, saying I've collected this information, what's the purpose, what's the reasoning behind this information, and if you retain information for a set period of time, that's quite a long timeline, make sure you check in and check yourself, as we say, before you wreck yourself, that it's still in line with the purpose of why I'm retaining this information. To ensure that you don't unnecessarily have to go back to your data subject or back to your clients, the POPIA Act says that we have to make sure that the information received is of a quality standard. So a responsible person must take responsible steps to ensure that the personal information is complete, accurate, and not misleading, and updated where necessary. So this falls back in line with the purpose of why we have information. So only can collect information which is relevant. If the data regulator, information regulator is at your doorstep and it asks what information you have in your possession, and you can't say the reasoning behind certain information you have in your possession, which goes beyond your scope or purpose of your company, then that could constitute as being misleading. So update your records where it's necessary, so you only have necessary information on your files, and that it's not misleading, or that it remains in line with the data subject's consent, and that it fulfills your purpose of why you have this information in your possession. So this requirement is only applicable to personal information, and it can be collected both manually and electronically. So if you physically draw these information from clients, or you have it through your website or your web portal, or however you collect your information via email, make sure that it's transparent, it's not misleading, and that it's in line with your purpose. And then we get to openness. This is pretty much self-explanatory. We have to ensure that we remain accountable for why certain information is in our possession. So the responsible person, I always say, must be open to a data subject about why they are processing the information, and the data subject has a right to know what's happening to the information. So they can always come to you with a request saying, what information do you have on record? This is usually done by way of a POPIA application, a promotion of access to information application to your company. So I hope you all have that in place. Then there can also be privacy policies and terms and condition guidelines, which sets out how this information can be obtained and requested. Now we get to the most important part, and this is usually what scares people off with POPIA. POPIA puts the onus on the responsible party to say there has to be security safeguards in place. So you must secure the integrity and confidentiality of personal information in your possession or under your control by taking appropriate, reasonable technical and organizational measures to prevent leaking of personal information. So practical steps you can take to ensure security safeguards on a very introductory level is don't open weird emails, don't leave your files unattended in your office. If you have other clients visiting you, make sure there's no information of other clients lying around where unauthorized persons can have access to these informations. And also don't leave your forms or your data subjects information unattended. Just an interesting fact I always say to people, did you know that 17% of your fellow employees use the password 12345667? So don't be that. Take that security measures in place and make sure that no one can have access or easily freely access to information that's in your control. Because remember, we are all accountable and responsible. So should there be a data breach, just to inform you as well, the information regulator must immediately be informed together with your data subject, unless the law enforcers indicates otherwise or there's a pending investigation. So just know if there's a breach, just with us as lawyers, we have to let the LPC know immediately if there's something went wrong or if there's a prescription. Same with you as a company. We are all accountable to the information regulator. So if there's a breach, immediately be accountable, inform them of the breach, inform the data subject of the breach as well, so immediate action can be taken. And then the last point is your security safeguards. So data subjects may request where their information is being held, and they may also correct or delete certain information held about them. So this basically falls back on the organization to say, how is my information being held? What does for example, my client database look like? How secure is it? How easily can we access it, delete it, or amend it to make sure that personal information is being stored safely and secured. So therefore, it's the responsible party's need to facilitate the data subject's interaction with the personal information they hold. So you can't withhold any certain information to the data subject if they voluntarily submitted it to your organization. They have the access to know what information you're being retained, how it's being attained, and what security safeguard measures are in place. And if it's found to be that you are negligent or there might be a potential breach, just know, as I've said earlier, the Act is very specific and they can impose a fine or imprisonment and then a further damages claim. So the POPIA Act, lastly, also refers to the POPIA manual, as I've briefly discussed. So this is your client or your data subject's right to access certain information. So just know, it's your responsibility, if you're engaging with the data subject, to ensure that the data has a purpose, it's correct, it's not misleading, that there's a consent, and that you as the controlling party took the necessary safeguards to make sure that the data is safe and secure, and that you as the data controller will prevent a data breach. So that's basically the overview of POPI and the 8 conditions they opposed therein. Thank you.
Much, Anrich. Really appreciate that, Anrich. We will now hand the stage to Marijan. So
thank you. Yeah, thank you, Eugene, and thank you, Anrich, for a lot of great information about both the Nvious solutions and the POPIA Act. I would also like to welcome everyone attending today, and thank you very much for being interested in the topic of protecting personal data and individuals' privacy. My name is Marijan, and I'm the CEO at Legit, where our vision has always been to protect privacy by providing companies and organizations with practical solutions for operationalizing privacy and minimizing privacy compliance risks. As a software vendor and a global player in the privacy protection area, we carefully choose our partners, and I'm very happy to have Nvious Solutions with us, as we see the South African market as one of our key strategic markets. My job today is to take the next 15 minutes and give you a high-level overview of Data Privacy Manager and how we help our customers. And for everyone connected, please check the chat area, and you will find an ebook named Understanding the POPIA Act, which is a guide to data protection in South Africa prepared by Legit and Nvious Solutions. So just a short introduction about Data Privacy Manager. We are a globally recognized software platform, primarily a SaaS platform. However, we do have different deployment options. We work in the area of privacy automation and governance. We solve different challenges. We try to cover everything that we have seen that has been a problem for our customers when it comes to data protection, trying to be compliant, minimizing privacy compliance risks, and operationalizing on day-to-day tasks when it comes to data protection. We have over 200 enterprise customers in over 40 countries worldwide, and everything we do is our own proprietary technology. Let it be noted that we are a deep tech company, so we use AI, machine learning, deep learning, technology, which is fully developed by us, very secure, proprietary. We don't use any third parties. We don't use any services that can leak personal data. So we have been very careful. And our story goes back like 8 years ago, when even when we started, there was a lot of questions how you can actually automate privacy and data protection. So we started basically with trying to do consent management in the right way, then expanding our offering to data processing inventory, so having the centralized records of processing activities, and then managing third parties. And today we have 10 different modules, which are combined into 4 different product groups. Our customers come from different industries. So today, data protection regulation applies to any company processing personal data, and today everybody processes personal data, be their customers or prospects or employees. So we really do have customers coming from different industries, and luckily for us, problems are pretty much the same or very similar, so the same solution can be applied to different industries. Our typical customers and users of the solution come from either privacy compliance, privacy operations, like data protection officers, which will typically use our governance part, where we try to decentralize everything regarding data protection. So we don't want one person in the company to be responsible for privacy and data protection. Rather, we want one person or a part of the organization to be monitoring everything. However, we want to delegate tasks to different people within the company. Then users of our solution would typically come from marketing, HR, and analytics when it comes to consent management and tracking opt-ins and opt-outs from the customer, and controlling what the company is actually processing based on the current status of consent. And also we do have data governance, analytics, IT, everyone who needs to keep track of the life cycle of personal data. So with Data Privacy Manager, we try to discover and find everything that the company is collecting with personal data, and then track the life cycle of personal data until the moment where the data needs to be removed from the systems. So on a high level, what we do when we speak about privacy program implementation, as a software vendor, together with our partners, for sure, we are focused on implementing the software and helping you when you use the software platform to actually get a lot of help and minimize any manual work that needs to be done, thus minimizing the potential errors that can happen. But a lot of times when we start speaking with customers and potential customers, since data protection is today a very complex area, we get a lot of questions about what should be the priority and what should the company do first. So we have introduced a services package that we call a state of privacy assessment, which is kind of a nice way for us to get to know you and for you to get to know us. But what we do is we actually do workshops, analyze your existing state of privacy, including the documentation, and we provide you with a maturity report, with recommendations for improvement, with a roadmap for implementation, which is technology neutral. And we provide you with an executive summary presentation and a list of identified risks. And this presents a nice baseline to actually start implementing and using the software. This is kind of a unique thing that we do, and it has proven to be a very good practice. And when we speak about maintaining and managing a robust privacy program management for the long run, because data protection is here to stay, we can also help with technical trainings and education, not just about software, but also about what are the best technical and organizational security measures that you should use in practice, what are the best practices currently when it comes to data security, and also helping you with internal and external audits. Now, when it comes to the common implementation approach, it typically has 5 phases. I have mentioned SOPA, the State of Privacy Assessment, which we call Step 0, because this is not really software implementation. It's rather preparing the company for software implementation. This is something that can be done quite fast. And it is, like I said, a very useful exercise, something to start with. And then the first phase typically is data discovery. So the challenge that companies have when we speak about data protection in general is understanding their data landscape. So understanding what are all the locations, places, documents, databases, and applications where you actually store, collect, process personal data. And also later you will see the company is not allowed to store this personal data indefinitely. So at some point you really need to either anonymize or delete personal data from the systems. So as a baseline for this, we use our data discovery and classification services, which can connect to any data source that you have and can automatically, using artificial intelligence, find and classify all personal information. On top of this, we also provide a personal data search service, whereby providing a specific identifier or personal data, we can very quickly find all the locations where this data is actually stored, all the documents, databases, and applications. And this is something when you think about implementation, it's also really fast. So we do this in a matter of maybe 2 months, map and connect to all your data sources and basically have an ongoing scheduled data discovery scans, which provide you with fresh information about all the personal data that you have and any new personal data type that some part of the company has started to collect. Now, the second phase in the common implementation approach is actually automating the privacy program management. And like I said, trying to decentralize and build a robust program. So we have a data processing inventory with the centralized records of processing activities, giving you real-time updates on what you do with data, how do you process data, what is the purpose, what is the lawful basis, who do you disclose this data to as like third parties, are you defining the purpose or are you a processor from the perspective of the role? And then managing any individual's requests in relation to the rights given by the POPIA Act. We also have a global database of retention records provided by Filers Keepers, which is our partner. So what we have here is actually they track all the laws in the world and basically extract the retention rules. So how long are you allowed as a company to keep personal data, or how long you can keep personal data? And the privacy program management is also something that is up and running quite fast. We can go live in production in a matter of weeks. And the third phase of implementing data privacy manager is related to consents and preferences. Now, it's important also to say that the solution is modular. So you can choose which modules to use, and it doesn't necessarily have to be in this specific order. So you could, for example, start with consent management. And the goal of consent manager is to have an end-to-end automation of the whole process of collecting personal data, collecting consents, be it opt-ins or opt-outs coming from the individuals through different interaction channels, basically having one single source of truth for consents, and then actually controlling how the company is processing data based on the current status of consents for each purpose and for each individual. And we also have a means to fairly easily integrate with the existing processes. So we don't want to come in, do the big bang and change everything that you do. We want to easily and seamlessly integrate into your processes, introduce a centralized consent management platform, and fix everything that needs to be fixed, but not change the way you do business. And the final phase, and this comes as a cherry on top of your privacy program management, is actually controlling the life cycle of personal data. So when the time comes to actually remove personal data from your systems, we can automate the orchestration of that part, understanding each individual data object, trigger for the data retention record, how long you actually need to keep the data, and then when the data retention period expires, we can actually automate the removal, be it deletion or anonymization of data from all the systems. Now, I know this is a lot of information in a very short amount of time, so I do want to ask you to get in contact with Nvious. So also use the Q&A section here on the webinar to ask any questions. So we will leave some time in the end to answer those questions as well. Now, one more thing that I want to show is what differentiates us as a software vendor and our solution from other players in the area. So first of all, DPM is a cloud native platform. However, we do provide both SaaS and self-hosted deployment options. And self-hosted can either be on premises using your hardware infrastructure or in your private cloud. Now, the second thing is that we are very fast and easy to implement. So we try to make things as simple as possible, not too simple, of course. And everything is modular, so each part of the software can be implemented fairly easily and very fast. Now, what we do have is a very clear long-term vision of what we want to do, and we have a big R&D team, and we try to utilize artificial intelligence at this point in an intelligent way and in a very secure way. Number 4 is that DPM leverages proprietary technology. So everything we do is our own development, our own technology. We are independent on all the other big vendors and big players in the area, so there are no risks from our perspective. DPM is also a modular solution, so you can choose which module to use and when. We have a very unique a concept of personal data classification using our proprietary artificial intelligence. It is very precise. It works in any language and any script. And also our consent management has for years been recognized as one of the best solutions for managing consents and preferences. It is a highly configurable, highly flexible solution, and it has proven to be able to solve any challenge when it comes to managing individuals, opt-ins and opt-outs, and everything that comes in that arena throughout the years. Also, if you have any questions, you can write them in the Q&A section, which you should see, I think, in the bottom of the screen. We'll try to answer everything in the next couple of minutes.
Thank you so much, Marijan. It was very informative. I trust everybody found it. I'm pretty sure they did find it informative. Of course, I can vouch that DPM, not that I'm biased, but it's a fantastic solution and does solve your privacy challenges that you will face. You are welcome, most welcome to post any questions that you might have, or raise your hand so that we can see you and then address those questions. Also, please put it in the Q&A. We can respond to that if you type it in there for us. If you need to reach out to me, I'll put my details within the box there, and then you gladly can call me, email me, and then we will be glad to see you and then discuss it in much more detail with you guys.
Okay, so Eugene, there's a couple of questions that I can see. One is related to the integration. So does the consent management module integrate with other CRMs and other online marketing platforms like Facebook? So in short, yes, we have a lot of integration options, and yes, the goal is to integrate with the CRM platforms and anything else that you use where consents are the lawful basis or are part of the process. So no, in general, no limitations to the integration options. Another question is related to the cookie consent. So the cookie consent is a specific type of offering. We have a partner network, so a network of partners that actually specialize in cookie consents. We don't see it as the part of the privacy program management platform, as more or less for cookie consents you don't collect that much personal information. So, but if you have any questions related to the cookie consents, we can help you with that as well. Another question is, in this case, we are applying DPM to POPIA Act. Can it be applied to different standards like GDPR, etc.? So yes, the DPM is a global solution, and we cover different regulations. So both in terms of the databases and the knowledge base that we have in DPM, and also the concepts which are more or less applicable to all the regulations as well. So whenever there is a difference between how a specific question is managed in different regulations, for example, the rules about consent, DPM is either provides different templates or is configurable enough so that you can use it on different geographies and for different regulations. I think the next question is pretty similar. So any compliance solutions where we can keep track of DPP legislation across multiple jurisdictions and monitor extent of compliance. So, I mean, that is the goal of DPM, is actually to give you an overview of the compliance, of the risks, and the different regulations that are applicable to you.
Marijan, this is a question there from Sushila. Do you have capability for records of processing?
Yeah, sure. It's a part of the data processing inventory. We have extensive capabilities around managing the records of processing. So it's one of the key things, and like I like to say that it's the heart of the compliance typically, because you really need to understand everything that you do with personal data and why you do it. So in short, the answer is yes.
And then the other one is data inventory linked to business processes.
Sure. So when we speak about data inventory and data processing inventory, we have two views. One is from the technical asset perspective, so what type of data is stored in different systems, and the other one is from business perspective. So what are the business processes where you actually process this data and why do you do it and which department is in charge and so on. So we do have both views.
How do you scan and discover data when metadata doesn't exist? Can your AI capabilities auto-generate and fill the metadata gap?
So when metadata doesn't exist, it's not a problem for us because we lean on data. So unlike a lot of other vendors, what we actually do when we do data discovery scans is we scan both the metadata and data. So if metadata doesn't exist, be it that we are talking about structured or unstructured data, we actually read the data. So the AI does the classification based on the real data, not the metadata. So it's really not a problem.
So if there's no more question, guys, then I guess I thank you once again for your time. I know you guys are all very busy. So thank you once again. Thank you for our panelists, Anrich. Thank you for making the time. Marijan, Maya, thank you so much. And then obviously from Kenneth on our team. Thank you, Kenneth. And yeah, thank you all. I do appreciate your time. And like I said, you're welcome to contact me. And I look forward to seeing some emails and my phone ringing off the hook. Okay. Thank you, guys. Have a wonderful day.
Thanks, Eugene. Yeah.
Thank you.
Have a great day. Bye, everyone.
Bye-bye.